All right, so I want to welcome you to what I believe is the third annual Forum on Montana Democracy, sponsored by the Missoula League of Women Voters and Missoula Moves to Amend. And the first thing I want to do is just ask you to make certain that your cell phone is off or turned down, put on vibrate or whatever, unless you're called to the Vatican. If you're expecting a call to the Vatican, then you may leave it on. No. I don't know anyone who's expecting it. So, my name is Linda Jillison, and I've had the chance to moderate all of these fora every year thus far. And I'm glad to be back because it's always an exciting evening to discuss with people who know a lot about the issue, what's going on with the Disclose Act, how it's affected us in Montana, and what's likely to come down the pike in connection with the Disclose Act. I wanted to explain what the connection of Missoula Moves to Amend with the Disclose Act is. Missoula Moves to Amend is a group which was put together back in, I guess, 2011, sometime like that. It was in response to the passage of the Citizens United decision by the publication of the Citizens United decision by the Supreme Court, in which was implied or stated that corporations are people and that money is the same as political speech. And Missoula Moves to Amend was one of many groups who began to work to overturn that decision. And we're joined by groups all around the country. As you know, there's a national National Move to Amend group. Our first action really was to collect signatures on the I-166 citizen initiative back in 2012, in which Montanans passed that initiative by a margin of 3 votes to 1, that we should instruct or advise our elected officials that they should assist us in overturning Citizens United. And that was a wonderful, strong statement from across the state of Montana, and we've been working ever since in that direction. This January the 21st, which is the birthday, the unhappy birthday of Citizens United, we had a citizen speak out with Missoula Moves to Amend, in which we had representatives from the JRPC, Missoula Interfaith Collaborative, Missoula Area Central Labor Council, 350.org, Montpurg, and the Missoula League of Women Voters. And our plan for that evening, and it was a wonderfully successful one, was to get together with all of these people who work with real human beings in our community and to try to find out what the real human costs of the domination of our political lives by large dark money is. And we had a very informative and collaborative evening, and that was a wonderful one. Our next evening, which is planned, and there's a little statement about it out in the hallway, is a visit by David Barsamian. I don't know how many of you know him. He's the executive director of Alternative Radio. He will be in Missoula in the middle of September to talk about voter suppression, because this is an issue which really has...
And I'm sorry, go ahead.
Is that what you're talking about?
No, I'm not. Go ahead.
Which really has, I think we've seen in the primary season thus far, had some pretty disastrous effects on our political lives together. So that's who I am, and I wanted to ask Nancy Leifer, my friend Nancy Leifer here at the other table, and I'll pass the mic to her, to talk a little bit about the interest of the League of Women Voters in this topic.
Can you bring those in? Thank you. You're going to do that? We could do that. All right.
Thank you, Linda. The League of Women Voters, just real briefly,
We were founded in 1920, and we've been around ever since. Dedicated to the whole idea of providing voter information, voter education, supporting voter rights, and voter participation in a nonpartisan way. The League does not endorse Republican candidates or Democratic candidates or any other kind of candidates. We are an organization that believes in empowering voters and doing whatever we can to help make elections fair and equitable. We've been involved in this issue for some time now. We have a position on money and politics with the League that says that the methods of financing political campaigns should ensure the public's right to know, combat corruption and undue influence, enable candidates to compete more equitably, and allow the maximum citizen participation in the political process. In fact, the League actually has a position in favor of public financing of elections in order to get rid of all of what we're talking about today. But that's a long way down the road. I just wanted to set the stage here a little bit with a little bit of a statistic that I found concerning the amount of money that's been put into elections since the Disclose Act was passed. The thing that struck me about this that was so amazing is that in the 2014 congressional elections, and just one second here, I'm looking for here it is. There was nearly $4 billion, 4B with a B, billion dollars spent just on congressional races in the 2014 election. And the amazing part about it, and the reason why I think we're all here today, and I know Chuck's going to talk about this a lot more, is that in that $4 billion, 1.7 of it was spent by actual candidates who had their own campaigns. But the larger share, 2.3 billion of that, was spent by independent outside organizations. So our elections have flipped to the place where the lion's share of information getting out there in elections is not coming from candidates with their own campaigns. It's coming from these other organizations. So that is a great concern. And as we'll hear from Chuck, Montana has had in the past excellent way of dealing with this, and we lost it and now we're regaining it. So with that, we'll just make one more brief announcement. We also are sponsoring a meeting coming up on the 21st of May, and there's a little flyer about it. Who's got them right now? Nancy Maxon has them. You got them? Okay. If you didn't pick one up, you can certainly pick one up. This is on the whole question of the role of delegates and superdelegates in the convention process for nominating presidential nominees. And we have coming to that forum the leadership of both the Montana Republican and Democratic Party and some seasoned folks who've been to national conventions from each party, as well as an historical perspective on where all of that campaigning and party stuff came from. This is all going to be on Saturday, May 21st at the University of Montana University Student Center Theater on the 3rd floor of the UC, starting at 7 o'clock. So I invite you all to come and hear that too, which should be a very interesting discussion. So with that, I will stop and turn it back over to you, Linda.
Thank you, Nancy. Thanks, Nancy. I want to point out that neither the League of Women Voters nor Missoula Moves to Amend is a partisan group. Missoula Moves to Amend sees our particular issue as an issue which affects both parties, potentially all parties in our American political life. And of course, the League is by law and by a mission statement nonpartisan. Okay, so for tonight, we're really excited to have John Model and Chuck Johnson back. Let me give you an idea about how things are going to work. We're first going to have a presentation from Chuck. Mr. Johnson is a senior journalist, a respected journalist in our state. Probably all of you know exactly who he is, formerly of the State Bureau of the Missoulian. And he's going to talk to us about changes brought about by the Disclose Act. And then Jonathan Model, our Commissioner of Political Practices, is going to talk about the enforcement of the Disclose Act, individualism meets community. Now, after Commissioner Model finishes, we're going to have a couple of minutes just to ask him clarifying questions. Not questions for discussion, but just to ask him to clarify in case anyone was unclear about what he has said. And then we'll have a discussion with both of our speakers, and then we'll be taking question and answers. And for that, you should have at least one card in your possession. If you have a question, oh great, you have the cards. If you have a question, just hold up your card, write a question down, hold up your card, somebody will come and take it from you, and Nancy Leifer will be reading the questions, correct? And that's in order that we be sure that the questions are heard clearly. We're being taped by MCAT, so it's important that everything's picked up by the mic. So that's the reason for the turned in questions, all right? So first of all, let's begin with Chuck Johnson, who will speak to us about changes brought about by the Disclose Act.
Thank you, Linda and Nancy, for inviting me again. It's always a pleasure to be here. I have great respect for the League and also the other group. Before talking about the Disclose Act, I'd like to talk a little bit about the state law that created the Office of the Commissioner of Political Practices. Prior to 1975, candidates in Montana were required to file campaign finance reports, but there was no uniform form. The reports went into the Secretary of State's office, and they weren't audited or anything. They just sat there, and you could look at them if you wanted to. The way this law came about, creating the office, was kind of interesting because in his 1972 campaign, Governor Tom Judge failed to report $94,000 in donations, where they came from, and about $84,000 in expenditures. And it kind of hung over him like a cloud for years. And so he did a noble thing, and he had a committee appointed to study election laws and came up with what we have now, basically. It was a different name then, but a lot of it's the same. The commissioner is appointed by the governor from a list of 5 names suggested by the legislative leadership, although the governor can pick anyone he wants and sometimes has. And the beauty of it is, unlike a lot of other states, the commissioner really reports to no one. The commissioner is independent. In some states, they have kind of a model like the Federal Election Commission, which is the FEC has 3 Republicans, 3 Democrats, and anything controversial ends in a 3-3 tie. And it's not an example of a great regulatory agency, in my opinion. So, and the commissioner is subject to Senate confirmation, and the appointment for a full term is 6 years, and the commissioner cannot run again. Now, we've had over the state's history 11 commissioners. Some have been short, including Commissioner Model. He's not serving a full 6 years, but I think it'll be, what, 2.5? 3.5? Okay. There have been attempts to gut this office over the years, including the last session, and there are attempts probably coming again this session by legislators to go to a mini FEC type system, or to place it under another elected official like Secretary of State or Attorney General, which to me would create an automatic conflict of interest. The office has played an increasingly important role in recent years with the emergence of dark money coming into play, especially in Republican primaries for the state legislature. And this is money coming from nonprofit tax-exempt groups registered as social welfare groups that are using money to influence election results in Montana. We particularly saw it with Western Tradition Partnership, which surfaced, I believe, in 2008 and came back in 2010, and a number of others. The office has struggled to keep its budget and keep its staff. At present, I think it has the most staff it's ever had, with 7 people, counting the commissioner. They've been housed in a tiny little house near the Capitol, then 2 houses, and now a single house, and it's as staffed up as it's ever been. And regardless of who the commissioner's been, I think it's fair to say that the staff is among the hardest working in state government. I always tell people it's critical to pay important to this office, pay key interest in this office, because it's very important to voters in Montana as well as candidates. And if you see efforts to try to weaken it or gut it, if you feel opposed to that, you ought to let your legislators know. The 2015 Disclose Act was an interesting one to follow. It was Governor Bullock's bill, and it was introduced by a Republican Senator, Dwayne Ankney of Colstrip. It got through the Senate in a fairly close vote, but it really ran into a difficult time in the House. The fellow that carried it was named Representative Frank Garner from Kalispell, a freshman. And it's an interesting story how he happened to do that, because Americans for Prosperity, the Montana chapter, was trying to get legislators to sign pledge cards saying that they would oppose expansion of Medicaid in the state. Garner and some other Republicans refused to do that, saying they wanted to hear the debate and then they'd decide. And they were greeted with Americans for Prosperity calling town meetings in their districts to basically let them have it. Well, all of the Republicans that were in this boat decided they really ought to show up to the meetings and defend themselves, and they also called a lot of their friends. And so, to the one, the meetings were a bust. They were dominated by the legislator and the legislator's supporters. Garner carried the bill on the floor and did a masterful job withstanding, I think, more than a dozen attempts to amend, and they got it through the House narrowly as it was. A key thing, I think, for the public, for the media, and for voters at large is the added transparency the bill provides. Prior to its passage, for legislative races, there was one filing period prior to the primary election, 12 days out, and one 12 days out from the general election period. Now, that doesn't work very well for a couple of reasons. One is, in the days prior, candidates for the most part filed their documents by paper or by fax. So the commissioner's staff had to scan it, put it online, and it wasn't really useful. It was late and not very searchable. The new law provides an additional reporting period, and besides the 12-day, and it's a 35-day reporting period. And that's interesting because absentee ballots go out 25 days before the election. More and more Montanans are voting absentee these days. In the past, until 5 or 6 years ago, you had to say, we're going to be out of town on election day, or I'm in the hospital getting surgery. You had to have a good reason to get an absentee ballot. And now you can just say, I want to get an absentee ballot. So the vast majority of people now are voting that way. So the timing is very good because people now can look at their legislative candidates and see where the money is coming from to buy the advertising, the flyers, the radio ads, the other efforts to elect candidates. Statewide candidates already file monthly and file electronically, but now this law gave the commissioner the authority to rule that the legislative candidates would have to file electronically too, with exceptions. And the commissioner can talk about this, but a number of legislators, a small number, legislative candidates have asked for exceptions in that they're not computer literate or don't have the ability to do it. The vast majority do, especially incumbents. The state now provides legislators with a laptop or a tablet computer, so they should be able to do it just fine. What's the advantage of having it filed electronically? Well, it goes up instantly. So you can look and see how much your legislative candidates have raised, who they've raised it from, how much, how they're spending their money. Are they buying TV ads? Are they buying flyers? Are they buying, the old days used to hand out emery boards and thimbles and matchbooks, but you can see how they're spending it. Or beer? Yeah. So this will be valuable for voters, I think, and the media as well. Prior to the new law passing, it was very difficult for news media people to do much on the way of legislative campaign filings. Yeah, they were out before the election, but by the time they all got up and were up on board, they were, you had to get copies, you could print them, but there was never much investigation. You would see stories saying that, Jane Doe raised $2,500 and her opponent Bill Smith raised $1,500, and that was about it. I'm hoping that this new law will give media and other groups to analyze the data a little more. And the other thing you could do online is download the forms. They're filled out. Now, I'm not complaining behind his back because I've told John the same thing, but I think the office should have detailed instructions how you download it to a PC and how you download it to a Mac. I've got a Mac at home and I've yet to be able to successfully download it, but if you can get those downloaded and put them in a spreadsheet, you can do nice searches. How many of the donors to a legislative race are from 59801? How many are from outside it? How many are Montana donors? How many are not? How many are retired? How many are people that work in everyday jobs? How many are attorneys? How many are doctors? So you'll get a really good profile of who this candidate is by looking at the donations. And likewise, how they're spending their money. What my old colleague Mike Dennis and I used to do with the statewide races, we would ask the campaigns for the governor and Senate and House, the US House and Senate, to provide us a list of all their donors on a spreadsheet on a CD. And then we were able to get a wonderful nonprofit in Helena named the National Institute on Money and State Politics to run it through their database, and they have literally millions of names in their database. They do this in all 50 states and happen to be based in Helena. And we would get a nice report that we would then run out and credit to them. And the odd thing is on those candidates, oftentimes the largest piece of the pie would be retirees. But it was always interesting to see where the money came from. Now a media group could even start building its own database of local donors. So I think it holds great promise for voters getting more information about their candidates, which is good, and being more informed voters, and it should be empowering. Excuse me here. I'm sorry. Nancy also asked me to talk about some of the challenges that have already surfaced in court to the law and the rules that were put in place to implement them. And there are some, and there'll be more coming. Election laws are very contentious, both at the campaign finance level, to the voting rights level, to the redistricting level. There'll be lots of lawsuits coming, as there are already. There's a pending lawsuit before U.S. District Court Dana Christensen that challenges the rules as a whole that were implemented by Commissioner Mogen's office to implement the Disclose Act last summer. It's the complaint was filed by the Montana Growth Network, which is a conservative group that opposed both the bill and Mogen's confirmation in the Senate. That one has not been decided. Another group, it's from Virginia, the National Association for Gun Rights, have sued over the provision in the Disclose Act that requires that would require it and similar groups to register as political committees in order to make issue advocacy statements that it claims are protected by the First Amendment. This is a very important case. If this group prevails, it will gut a lot of the law. The AP reported today that the state is defending this law, which requires these groups to file reports, to disclose their contributors, and open bank accounts. And they argue that this state law doesn't violate the law, but simply requires reporting. And the Citizens United decision, which came down hard against limits on what corporations as well as unions could spend on independent expenditures for and against candidates, has a big section in there arguing that disclosure is critical and defending disclosure. So we'll see how that goes. There's another pending federal court case that's been in the courts for a while that says if a group mentions a particular vote by a candidate, a legislator, incumbent legislator on a specific bill, that it has to mention every vote by the legislator on that particular bill, not just an isolated vote. And that's in federal court as well. Has been there, and there have been some preliminary decisions over the years, but it's back in court. And one of the cases that's gotten the most attention of statewide has actually been a case that the commissioner filed against Art Wittig, a prominent state representative from Bozeman, formerly a state senator. And about a month ago, a jury convicted him of illegally coordinating with nonprofit third-party groups in his primary race in 2010. And the jury found he illegally accepted corporate contributions but failed to report all of them. This is a case that I think will not be resolved in finality when the judge passes the sentence, because one of Wittig's co-counsel is part of a national law firm that specializes in so-called free speech cases, that money is free speech. So I have a feeling this will probably wind up in federal court. But I think we'll find more lawsuits coming, and that's not unusual. On the one hand, new laws spark new lawsuits, but I think this one will probably prompt a lot of them. There's also a challenge pending in federal court by some Republican county central committees that would allow only registered Republicans to vote in Republican primaries. And they argue that Democrats and independents are unfairly influencing their results. This is not directly related to the commissioner, but it's another important election decision and could greatly change how Montanans vote in primary elections. I'll conclude by just saying that the Supreme Court Citizen United decision has had a monumental effect on elections at all levels. And I don't see that changing, barring a change in the Supreme Court, which may happen. As you know, Justice Scalia died, and there are 8 members on the court now, and the vote on the Citizens United case in 2010 was 5-4, with Scalia voting among the majority. So, and of course, President Obama is trying to get a replacement justice on, and is running into roadblocks from the Republican senators. So we'll see what happens. Before I close, I'd really like to put in a pitch for a book I just finished a while ago called Dark Money by Jane Mayer, who's a New Yorker writer, and it's primarily about the Koch brothers and their friends and colleagues. If I have a criticism of the book, I don't think it did as much as it should on Democratic donors like George Soros, but it's a very fascinating read about how the Koch brothers and the others have kind of pooled their resources almost to create a party that's got more money than the National Republican Party. Thank you.
Thank you. I don't know
Okay, thank you very much, Chuck. That was interesting, and I'm sure we'll be watching for these challenges along the way. And I hope they're covered by the Missoulian and other local media. Next, we have Commissioner John Modell to talk about the enforcement of the Disclose Act, which is his bailiwick. Individualism meets community. That's right.
Well, I'm very pleased to be here. And for those of you that don't know me, I'm Jonathan Modell. I practiced law in Helena, Montana for 31 years on a small law firm on downtown Helena. We call it Last Chance College. That's the main street in downtown Helena. And then in May of 2013, I was appointed by Governor Bullock as Montana's Commissioner of Political Practices. And then I was confirmed as Montana's Commissioner of Political Practices in the last vote of the 2015 legislature. And so that's the position I hold now. And what I'd like to do is just talk briefly about the enforcement part of the Commissioner's Office. Now, Chuck mentioned the reporting and disclosure part. So the Commissioner's Office, with its 3 staff at one time, and then 5 staff, and then 6, and now 7 staff, has a very narrow band of responsibility. Its responsibility is in the area of campaign finance, and the relation of the public trust doctrine in the state of Montana to the way in which campaign finance plays out in regard to expenditures and contributions in campaigns. We call that area campaign practices. So one area is campaign practices, the second area is lobbying, the third area is ethics. Within those 3 narrow bands of responsibility, then, the Commissioner's Office has a broad reach of authority and responsibility. Its authority and responsibility spans all reaches of government. So all the way from the Governor's office to the City Commission office in the area of lobbying, campaign finance, and ethics. There's some exceptions. County attorney has responsibility in some limited areas, but generally the Commissioner's Office is the place where you start with. Now, that does lead to some interesting questions. One of which is not reporting and disclosure. Now, as Chuck mentioned, the office has had a historical presence in reporting and disclosure, which has been very positive, regardless of whether the commissioners have been there, whether they've been approved, whether they've been appointed, whether they've been confirmed. Reporting and disclosure has gone on primarily because the office has had in its staff level an almost unbroken string of competent staffers. Mary Baker in particular has been there about 20 years. Kim Trujillo has been there almost as long, and now we have a new staffer, Elisa Spade. So the Disclose Act, which I think was a great step forward for Montana, required that the Disclose Act itself statutorily required an additional reporting period, as Chuck said. Then the regulations passed under the authority of the Disclose Act required electronic reporting for legislative candidates and for political committees. So on Monday of this week, statewide candidates who filed in the first of the month reported electronically. On Tuesday, the 35th day before the primary election, then candidates and political committees reported electronically for the first time. On Tuesday, Mary, Kim, and Alyssa, just because of the way it works in Montana, we had a limited amount of money to build that electronic reporting program. It went into the actual, all of that money was spent on a candidate or a political committee interfacing with the electronic system, SIRS, using that system, reporting and disclosing the money in a way that then was displayed instantly to the public through the SIRS icon on the Commissioner of Political Practices website. But we didn't have enough money to make that an interactive system. So when a candidate or a political committee developed a problem as they were trying to report, there was nothing that said, well, electronically responded, do this or do that. So how does a candidate, well, they call the office. They were instructed to call. So on Tuesday, Mary, Kim, and Alyssa, and then spill over to our attorney, Jamie, if necessary, averaged every 2 minutes on Tuesday from 8 in the morning till 6 at night with an hour off for lunch. So that's 30 phone calls an hour, 270 each. They took about 270 phone calls each, mostly with candidates and committees. In addition, they handled about 100 emails each. But in that day, and they starting Friday the week before, there was an increased amount of traffic, but it was successful. In a cooperative, collegial, generally cooperative and collegial way, with very, very few exceptions, all the candidates and committees who registered and reported through Sears, with the exception of 7 candidates and 10 political committees who were granted a waiver and were allowed to file hard copy. They filed electronically. So I think that's a pretty marvelous step forward. Now, I'm not saying that there weren't committees or candidates. We won't know that for about 3 or 4 days. Tomorrow I'm going to go back and examine all of the committees. There may be committees that failed to report and disclose, but that's not the same as the issue of whether the electronic reporting system worked as far as reporting and disclosure. It did. So we have a workable system, which is remarkable compared to the struggles that other states have had. And it will get better because of comments like Chuck's will now make it more accessible to the public. Once we know we have a workable system, we'll then develop indexes, we'll then develop ways in which the public can access the data that's in those electronic reports. So I'm pretty pleased with that. That is historically consistent with what the Commissioner's Office has been able to do well, regardless of commissioners, since its inception. And it's part of the reason why we still have a Commissioner's of Political Practices Office, because what the Commissioner's Office has had difficulty doing, for very good reasons, is enforcement. Now, what exactly is enforcement? Could we put that first slide up? Okay, this is the final jury verdict form for the jury that came back with a verdict on April 1st, Friday, April 1st, so about 3 weeks ago. And if you look at the top, the name of the case is the Commissioner of Political Practice versus Arthur Woodick. Commissioner's Office, of course, and that's me named there. We're the plaintiff. Arthur Woodick, for those of you who don't know, is an attorney from Bozeman. He's a sitting member of the Montana House. At the time this particular thing concerned his activity as a candidate for the state senate from the Bozeman area. And here's what the jury came back with. Question 1, did the defendant fail to maintain and preserve records of his campaign contributions and expenditures in his 2010 primary election? And as Chuck mentioned, it was the Republican primary elections in 2010 that we saw the greatest difficulty with, also in 8, also in 12. The jury came back yes. Question number 2, did defendant Mr. Woodick receive or accept corporate contributions, including coordinated in-kind contributions, in his primary elections in violation of Montana campaign practice laws? The answer is yes. Keep in mind the in violation of Montana campaign practice laws. Could we go down to number 3? Did the defendant fail to report and disclose, report all contributions, including in-kind contributions, in his 2010 primary? Yes. The answer was yes. 4, what amount of corporate contributions, if any, did defendant accept or receive? $19,599, and then failed to report and disclose that same amount. So what is that jury verdict concern? Well, it basically is the state of Montana acting through the office that it has placed to enforce campaign practices, the Commissioner's Office, then through the jury has said that this particular candidate, Mr. Whittick, failed to meet certain community standards as to how campaigns should be conducted. Those standards concerned acceptance of corporate contributions, maintenance of proper records, and reporting and disclosure of amounts. Now, how did that come to be? Why was it 2016 before the Commissioner's Office was enforcing a 2010 campaign? And how exactly did you end up with that candidate in the first place? Therein lies the story of the part of the Commissioner's Office that the Commissioner's Office has struggled with. And there are good reasons why the Commissioner's Office, could we go back to the title of that? Okay, so we all know when the community, acting for community interests, deals with some act of an individual in the community. And the most recent one that struck me was do you remember about a week ago the big headline where Fish and Game has set up a separate unit to deal with serial poachers? So you've got an individual who's poaching. He's probably got a strong individual interest in poaching. If it's a grizzly, if it's a bear, he's probably selling the bladders and the gallbladders. But there's a financial reason why somebody would be harvesting wild game, regardless of season, regardless of number. They're probably making money off of it. And yet there's a strong community reason why you don't want that to happen. A lot of people have an interest in the animal, independent of hunting. They don't want to see that animal killed like that. Other people, probably more, have an interest in hunting. If that animal is going to be harvested, then it should be harvested fairly, with every hunter having the same opportunity to harvest that enormous spread of antlers if it's a bull elk, or the hide if it's a different sort of animal. We don't have much difficulty having the Fish and Game act as the steward of the community to go after that serial poacher, because I think it's pretty universally held that the serial poacher is acting adverse to community interest, and there's not a lot of respect provided that poacher, right? Not true for this situation. This is entirely different. You've got a state agency, which, as Chuck said, is deliberately set up as an independent agency, as it has to be, because you could be prosecuting the governor for a campaign practice violation. You could be after the Attorney General. Those people are afforded great deference, and rightly so, by society. They're not a serial poacher. They're a highly respected public official. Mr. Whittick is a highly respected public official. He's an elected state senator from the Bozeman area, and yet you've got a state person going after him. Now you ask yourself then, how exactly did you get to the situation? And scroll down, you can see that it's signed. Did a citizen in Helena, Montana sign this jury verdict form with a return against Mr. Whittick? How did we end up in that situation? Because it's a pretty perilous situation for everybody involved. It's perilous for the legislator, it's perilous for the commissioner, it's perilous for the society. You've got to be in some sort of a pretty extreme situation to end up in that, and that's what I'd like to talk about tonight in terms of enforcement. Exactly what are we trying to enforce when we have those three questions on reporting, on corporate contributions, and a failure to report and disclose? If we could go to the next slide, which is the public trust doctrine. Montana has this doctrine, and the last sentence is the key one. A public officer, legislator, or public employee shall carry out the individual's duties for the benefit of the people of the state. That's the core of what the Commissioner's Office does and what it is charged to do whatever a legislator does, including their candidacy, has to be for the benefit of the people of Montana. It can't be just for the benefit of the individual. If we could go to the next one down then. And this is only in Montana that moved to amend and said that they worked on I-166. This is the subsection 2 of I-166. I don't know of any other state which has this policy, which supplements the public trust doctrine. It says that passed by 72.4% of the voters of the state of Montana in 2012, people of Montana regard money as property, not as speech. People of Montana regard the rights under the United States Constitution, the rights of human beings, not of corporations. People of Montana regard the immense aggregation of wealth accumulated by corporations to be corrosive and distorting when used to advance the political interest of corporations. People of Montana intend that there be a level playing field in campaign spending that allows all individuals, that by the way is totally unconstitutional, D, but where you can apply it constitutionally, you apply it. And then E, people of Montana intend a level playing field includes limits on campaign contributions, limits on large contributions to or from expenditures. So from the commissioner's perspective, you take that statement of policy, so clearly articulated by the people of Montana, and you apply it in instances like Mr. Wittig's situation with the public trust doctrine, stating that candidates serve the people of Montana. If we could move to the third one down then.
Can you please speak to the microphone?
Oh, okay. The third one down. There's a lot of law on this. This is the summary of it. That's the place where it is. Each candidate and political committee shall file with the commissioner periodic reports of contributions and expenditures made on or behalf of the candidate. It's an elaborate law with a lot of subsections. I just gave you but relating that to the public trust doctrine, what it says is that candidates for public office in Montana, even though it takes a lot of ego to run for public office and you have to be a strong person to be willing to do it, there's a degree of humility that has to come with it too. I've sat through a lot of campaign report inspections for sitting senators, sitting House members in Montana, Senator Buttrey from Great Falls for one, Senator Cannell from the Bitterroot for another. Those people come in with their banker's boxes full of their campaign records, and if they have an expenditure or contribution that's called into question, they've got the receipt for it. They've got the name and the address of the contributor. You'd be proud to see the way in which their campaign records have been maintained. That's what this requires. Not only disclose to the public the report on the contributions and expenditures, but also they've got the backup to show that the reports are proper. And could we go to the next one? A corporation or union may not make a contribution to a candidate directly or through an intermediary. So those are the laws that were used. The way trials work is, this was a 5-day trial. At the end of the 4th day, the judge determined what the law was, and he also determined what the documents were that the jury was going to use to make its decision. So the judge in chambers with attorneys from both sides present spent about 4 hours determining all of the jury instructions that were going to go to the jury and also that jury verdict form. He approved that jury verdict form based on these documents, and the law was then given to the jury, and based on that they came back with a jury verdict. Now your question is going to be just exactly how could they come back with that sort of jury verdict, and why 2010 now? And that then relates to some of the issues that Chuck related earlier. So the commissioner's office historically has always managed to the best it can. It's doing it much better now because of electronic reporting, has always managed to take in campaign finance reports and as speedily, accurately as humanly possible. They've gotten them up. They've generally been scanned, PDF'd, and posted on FileNet. And now with the electronic reporting, as they come in, the staff take those electronic reports. They're posted up on a site called SIRS that everybody can look at. But in addition, they're saved as a PDF. They don't have to be reported or scanned, but the PDF then goes over into that old FileNet system. So it's recorded twice. If you're comfortable and you remember the old FileNet system, you've still got it. But if you want to look at it in SIRS, you can go into SIRS. The beauty of SIRS is that it's not only the information on that candidate, but it's data. As data, you can search it. In each election cycle, we're only going to get better as making that information better and better searchable. This is the first time around that we've had that information in searchable form. It's still searchable, but it takes a little more of an interface with your computer, and you got to practice a little more. Now, going back to where the commissioners were, in 2008, in the Republican primary elections, a number of Republican candidates faced a concerted, what looked to them to be a concerted direct mail campaign that they hadn't expected, and a number of them lost their positions. It surfaced again in 2010, it surfaced again in 2012. The commissioner in place in 2008 was Dennis Unsworth. He studied the 2008 election, and by 2010 was able to release a report identifying what at that time the commissioner's office thought was the responsible party, a group called Western Tradition Partnership, that eventually ended up in court in a decision holding that they illegally participated in primary elections in 2008. Mr. Unsworth left the commissioner's office on December 31st, 2010. In 2011, the governor appointed Jen Helmsley to replace Commissioner Unsworth. The Republican Senate on the last day did not approve Ms. Helmsley. We didn't have a commissioner. The second commissioner appointed by that governor to replace was a commissioner called David Gallick. Mr. Gallick was not successfully able to work with the staff at the commissioner's office. He resigned. He was then replaced by Jim Murray, who went before the 2013 legislature, was again not approved. I was then appointed in May of 2013, following the end of the 2013 legislature, took office on June 10th, 2013, and once you're appointed, you have the full authority of office. You don't have to wait till the Senate confirms you. You are a full commissioner of political practices. You can act with the authority of the commissioner's office, but you can only act until the end of the next legislative session. I was approved at the end of the next legislative session on 29 to 21 vote by the Montana Senate. 21 Democrats, 8 Republicans. So it was a bipartisan vote. It wasn't just the Democrats voting. And I say that because there are two issues with the history of the commissioner. Mr. Gallick was an attorney, but with the exception of Mr. Gallick, I was the only other attorney appointed as Commissioner of Political Practices. And those issues that Dennis Unsworth faced and that the succeeding commissioners faced in 8, 10, and 12 were heavily legal issues. They required an ability to look at complaints in a way that prior commissioners had not been required, and the complaints were more numerous. When I took over the office in June 10th, 2013, there were over 60 complaints on the docket. And a lot of those complaints concerned the 2010 elections. Now, how did Mr. Whitty come into effect? Well, there was a base of documents. There were 3 sets of documents that you could look at concerning the 2010 elections. And looking at those documents, I was able to identify 9 legislative candidates who looked like they were cooperating with Western Tradition Partnership, Mr. Whitty being one of them. We then proceeded to do what we do administratively. We issued an administrative decision called a sufficiency decision, saying there are sufficient facts based on the documents we have to believe that there was a campaign practice violation for these candidates. That was including Mr. Wittig. They were all Republican candidates because all the complaints concerned Republican primary elections. Then, in order to enforce that sufficiency decision, you have to, within 4 years of the date of the actions, you have to go to district court. Or you lose your ability to enforce a campaign practice violation. We took all 9 of those 2010 Republican primary election cases to district court within the 4 years. Mr. Wittig's case was the 5th one that we then moved along. There were 2 that had settled, 2 that were decided by judges in default decisions. Mr. Wittig's then was the first one that was decided by a jury. Mr. Wittig requested the jury. It was a full jury trial. Now here's where I'm leading to. Bear in mind that I've told you why the Commissioner's office was slow. It has to do with the change in leadership. It has to do with the natural tension that is going to be there between the office and the individuals it's going to control. You can't imagine a House and a Senate are going to be generally happy about a Commissioner of Political Practices office, which has oversight functions on campaign practices for it. No matter what you say, there's always going to be an antipathy there between that office and the Senate. But of course, what went on in 2015 was bigger than that, and I'm going to suggest 2 other reasons as to why there was this greater amount of antipathy. What exactly happened with Mr. Wittig? Chuck was there for some of the trial. My wife, Lorna, was in the back, was there for a lot of the trial. Here's what the jury saw by the end of the trial. What the jury saw by the end of the trial was a series of young people who used to work for a Washington corporation called the National Right to Work Committee. They were paid by the National Right to Work Committee, even though we originally thought they were working for Western Tradition Partnership. They weren't. They were all working for National Right to Work Committee, either directly as employees or they were associated with them as corporations. The National Gun Owners Association was an affiliated corporation run by a National Right to Work staff person out of DC. That we knew originally that the candidates had letters that were generated out of a print shop in Livingston called Direct Mail Services, Inc. We didn't know that it was a National Right to Work print shop. We do now. The jury heard that. The jury heard in the end that all those 9 candidates, including Mr. Wittig, received from paid personal staff services from people paid by National Right to Work. Services that included Jed Coburn of the National Right to Work Committee wrote candidate Wittig's letters. Another one, Andrew O'Neill, put his website up. Another staff person by the name of Sarah Anderson at the time, Sarah Arnold, did all this opposition research, organized the candidate school that he went to. Christian O'Neill himself was his overall campaign manager, provided him campaign advice. The graphics were provided by Andrew O'Neill. Those paid professional staff services provided to those National Right to Work sponsored candidates and picked in Republican primary elections, and what they gave them was called the works, was valued by the jury at $19,599. That's what the jury heard, that's what the jury believed, that's what the jury came back with. Now, where did that information come from? It didn't come from Mr. Wittig. Mr. Wittig never produced a document. He produced 66 pages of campaign finance reports, and in the end, he produced another 33 pages of receipts. No emails, no communication, but yet there were a lot of emails. Where did the emails, where did the memos, where did that information come from, showing Mr. Wittig communicating in January of 2010 with Mr. LaFleur? They came from those young employees. Because the attorney that provided pro bono services to the Commissioner office, Mr. Gerussi out of Billings, traveled to Seattle, he traveled to Rapid City, he traveled to Virginia, but using subpoenas and his own personal power of persuasion, he was appointed a special attorney general. He received and got the computer databases that those National Right to Work employees had preserved, was able to present and winnow about 60,000 pages of documents down to what he presented to the jury. That's what the jury saw. And I sat through the whole trial, and I totally concur with what the jury did. We had a major infusion of corporate presence into the 2010 Republican primary elections on behalf of the National Right to Work Committee, a Virginia-based nonprofit corporation affiliated with these other Western tradition partnerships and the other corporations that we're familiar with, but they were working under the authority of or in conjunction with National Right to Work field staff or National Right to Work paid staff. That's what it was. That's what the jury found. Now, how did we get in a position where we had candidates being willing to work with them? Well, can we put the next one up? Here's the nub of what I'm going to tell you on enforcement. I believe we're there. This is one of the other 9 candidates. Joe Boniak was elected. He was elected in 2008 from the Livingston area. He was defeated in 2010 by a candidate named John Esp out of Big Timber, another Republican candidate. John Esp was responsible for one of the original document archives that we had because his family is so numerous in the Big Timber area. They were actually able to collect and assemble all of the documents that direct mail was sending out, including hit pieces, hit flyers, attack letters. One of the strategies that they used was the candidate would put out probably the most influential thing that the National Right to Work group did was they did surveys into each legislative district. They developed a database of issue-based voters who would support a particular position on guns, life, taxes, and small government. Once they identified those voters, the candidate's letter was then mailed out to those group of ID voters, and on each side of the candidate letter was mailed, if it was guns, the National Gun Owners Association sent out an attack letter attacking the non-works candidate. In Mr. Whitty's case, it would be an individual by the name of Mr. Moran. He was attacked before and he was attacked after the candidate's letter being in the middle. So Mr. Boniak, Mr. Esp was able to gather all of those letters in a way that we weren't able to get from all of our other document archives, and so he had the best demonstration. But I would like you to go to the last page, which is page 24, and then I'm going to have you back up to 21 and 22. Okay, let's go back up, right there. This is a decision, August 13th, 2005, by the Honorable Gregory Pinsky, District Court Judge. This is a Montana District Court Judge, okay? So that's the key. I want you to think about that. It was a default judgment. Mr. Boniak wasn't there, but it was an all-day hearing. The Commissioner's office, myself, I presented the evidence on behalf of the people of Montana. Would you go to page 20? Okay. A little higher, just a little higher. No, a little higher up on 20. All right there. Candidate Boniak acted in concert with assigned agency or corporate entities. Okay, those are some of the groups that I listed. So, again, this is the court finding that this particular candidate acted with an assigned group of corporations. Then go to the next page. Judgment. Assessed a monetary fine of $27,182, which is 3 times the amount of the money that he found that the candidate received. Assessed it twice, once for the illegal corporate contribution, once for the failure to report and disclose. And then go to page 23. And one up. Okay, and the bottom of it, please. Okay, there, right there. The court hereby decrees and orders that that the candidate be prohibited from filing or running for office again until he files his supplemental 2010 campaign finance reports, disclosing the amount he got from campaign contributions that he did not report and disclose. Now, would you go to the next document, please? This is a document filed by Mr. Boniak in this proceeding. And you can see he calls himself the living man. Would you go to the second page of that document? Okay, right there, stop. Joel Boniak is not under the jurisdiction of the First District Court of the state of Montana. This is the point I wanted to make. Part of the reason why we're in court in the 2010 is an overreach, in my judgment, of individualism. That community interest that we accept so well when it's the Fish and Game moving against the poacher. Rightfully so, because every one of our public officials gets great deference, but we've gone too far. We've gone to the point where we're getting no respect for the community interest at all. This person was a legislator, and he's not accepting the jurisdiction of the first jurisdiction. So he's not accepting community's jurisdiction at all. Would you go to the next document, please? And this is a letter after the judgment. And the point on this is, he said, you've entered a judgment, I object, I don't consent. A word from the Supreme Judge of all mankind comes to mind, and he cites Luke 13:3-5. Now, I don't doubt, because I did sit through a deposition with him, and I know he's devout. And his faith is there, it's apparent. But the public trust doctrine holds that holding of office in Montana is for all of us. And it isn't something that you determine on the basis of your relationship, your own personal relationship with God. That's something that belongs to your church. So that's part of the problem. Now let's go to Mr. Wittig's. If you go to the next one, which is the COPP's memorandum of costs. All right, so this is the memorandum of costs that the COPP submitted after Mr. Wittig's trial. And would you scroll down, just go down it kind of 7 pages. So you get the prevailing party, which is the commissioner's office, recovers the expenses that you spend to try the case. Right down there, stop, cost of motion. Look at the number, 35. Now keep going down. Keep going down. Keep going, okay, stop, go back up. We prevailed, the commissioner's office on behalf of the people of Montana prevailed on 29 motions. There was a motion to add third parties, the governor, former Commissioner Murray, and myself personally. There was a motion, there were counterclaims. There were motions to disqualify witnesses, every witness that we had in the trial. It was as heavily litigated as you can possibly, which Mr. Wittig's right to do that. He certainly could do that. But here's the second point. Mr. Wittig certainly is not in the category of Mr. Boniak, where he's saying his individualism triumphs over the community. But he is in this category, I think. And before I say this, I just want to preface this. The court's sentencing judgment penalty hearing, I guess, is June 17th, 2016, so it's in about a month and a half. I'm talking just about the jury trial here. I may present testimony at that sentencing hearing. I'm not prejudging that. I'm not talking about sentencing. But it is fair to talk about how you ended up with a jury verdict against a city public official. And I think then this comes into it. It's, is there an acceptance on Mr. Whittick's part of the role of the public trust and the role of the enforcement of the public trust? And I have to say, after the full Whittick trial, is no, there wasn't an acceptance of the legitimacy of the state of Montana enforcing that through the commissioner or any other enforcement, that there was a belief that public official status was bigger. So how did we end up in that situation from what happened in 2010? I think it's two places. That the commissioner's office, for the reasons I gave you, despite its historical ability to present information and the strength of its staff in doing that, did not have a historical strength or ability to enforce. Enforcement was new. This is, Mr. Whittick's case is the first enforcement case in 75 years in the state of Montana. It's the first time a judge or a jury in a contested hearing has found a public official to be in violation of the public trust doctrine, to be in violation of the campaign practices. So it was something that had to be done. And we might not have been able to do it as a people of Montana, but for retired attorney Gene Gerussi, who came out of retirement and did it pro bono. The commissioner's office, because of the unique structure of it, was able to appoint Mr. Gerussi as a special assistant, as a special attorney general. He represented the state as a special attorney general. But we have about $46,000 total for all of our litigation for the entire year, and it took over 30 just to try the case. There wasn't money there to pay an attorney, and so his time was given to the state free, and he did just an exemplary job for us. And I think the combination of the reason it took so long was it took that long for the series of, I am the 8th confirmed commissioner in the state of Montana, I am the 11th appointed. And in this 6-year term, I am the first one that's been confirmed. That lag time in confirmed commissioners, and also the movement toward a commissioner who's an attorney, meant that we were in a delay period from 8, 10, and 12 in being able to enforce on these things. And in addition, the fact that it could even happen, I think, is because as a country, we've pushed too far towards individualism in our candidates. We've moved away from the presence of community, the presence of the public trust, and that let our candidates get in a position where, unbelievably enough, they would work with a corporate conglomeration that came in and offered them these services in a primary election. They did it in 8, they did it in 10, they did it in 12. If they did it in 14, I didn't see it, and I don't think we're going to see it in 16. But the fact that we had it in 8, 10, and 12 is enough. So that's my presentation. Enforcement and reporting and disclosure. I don't think reporting and disclosure can stand without enforcement. Why would people report and disclose if it's not done equally and applied equally to everybody? Yeah, I suppose there's always going to be well-mannered candidates who will report and disclose, but you're going to expect your opponent to do it too. And when you get Mr. Esp facing Mr. Boniak, and Mr. Boniak isn't reporting a dime of the works that's given to him, it's not good. And that's where enforcement has to come in. You got to have the two together, but it's got to be done carefully because it's a very dicey area when you're enforcing against a public official. You've got to have, you've got to tread carefully and not overreach. And at all times, you have to respect the person you're against, whether it's Mr. Whittaker or anybody else. You've got to respect their public official status at the same time you're enforcing. And I hope we've done that. We've certainly tried to. Okay, that's it.
Wonderful, thank you. Okay, now we've built in a few minutes here for people just to ask questions, clarifying questions from Commissioner Mogul. If there's anything that he said that you're not clear about, tell us your name and then ask your question and make sure we can hear you.
And would the person who's answering the question please repeat the question so we can pick it up?
Okay. I'm Charlie Gonerman. My question is that this applies to all candidates, not just that they've been elected. Is that? I mean, don't have to wait until they're elected. It's any candidate.
Right. Should I
Would you
answer?
repeat the question, please?
The question was, does it apply to all candidates? Yes, the public trust doctrine in reporting, disclosure, maintaining campaign records, that applies to all candidates.
But they don't have to, they may not have been elected, but.
They could have been defeated in the primary.
Yes, okay.
Yeah.
This may be a Mr. Boniel question. I think there are some adherents of natural law that think that our politics move through a voting process, and that when political problems arise, we should seek political solutions. Let the people decide to vote someone out. And this viewpoint is expressed by a lot of people. And basically they're saying we shouldn't have an office of the Commissioner for Political Practices. And so.
Pardon me,
any
John,
comments there?
is this a clarifying question from the Commissioner, or is it a different kind of question that would need discussion?
It arose from his presentation.
Okay. Does it seem that you can clarify that?
Yeah, well, do you remember the movie Rollerball? James Caan?
I haven't seen it.
If corporations differed in the way in which their policies were, they hired two teams, sometimes to fight to the death, to determine who would do it. And so that's the other extreme from the community standard, is that sort of approach. But I don't know, I think we can talk about that again in the general election, but I think Montana's pretty crystal clear in its I-166 vote is crystal clear that we want to apply community standards to elections and not some sort of individualistic, unanchored standard that's away from the community. Did that answer your question? No? Doesn't look like it.
Maybe
The
we
political
can
solution.
deal with that when we talk about the future of the act as well.
Mhm.
Another question here, let's get, tell us your name.
I'm Jim McLean. Mr. Mold, the press has reported that there's maybe another hearing involving corruption with Art Reed. Could you explain that process?
Well, if Chuck is right and they raise constitutional, so far they haven't, they've stated but not actively briefed or litigated constitutional objections to our laws. If they do raise constitutional objections, then the defense is that the activity involved constituted quid pro quo corruption, because that's the only standard that Citizens United said preserves your laws if they're challenged on constitutional standards. If that's raised, then we should be allowed to put evidence of quid pro quo corruption, and here's the evidence. National Right to Work gave $19,599 in illegal corporate contributions, or orchestrated it to 9 candidates, including Mr. Whittaker. That's the quid. What's the quo? Mr. Whittaker in 2011, after his 2010 election, what's the first bill he asked to be drafted?
Right to work.
Right to Work. Now, of course, Mr. Whittaker didn't need to be paid $19,000. He was for right to work, whether or not he got the corporate contribution, but that's not the issue. It's the appearance of corruption. If you accept, as the jury found, $19,599 in money from a group of corporations led by National Right to Work, then anything you do on their behalf is the appearance of corruption, because that's how it's going to appear to the public. So we're very interested in that second showing, but to get there, they've got to challenge the constitutionality. They know we want to make that second showing. They've been very cagey about whether they're going to challenge it constitutionally or not.
Anybody else? One more.
I just have clarification on, I think on the national and possibly the state level, candidates are making a lot of personal contributions. How do you differentiate that they say it's their personal money that's going in versus the corporation that they may represent somehow? Am I saying that clearly? I'm not sure.
Right. So the U.S. Supreme Court has said that it can't.
Repeat the question, please.
Our personal contribution is constitutionally protected, basically. And
I mean, yeah, I guess
Yeah.
maybe that's,
Yeah.
rather than saying that they're really representing them.
right, they are. You can give an unlimited amount of your personal wealth to your personal campaign. That's what the Supreme Court has ruled. We're a nation of laws. We follow the laws, whether we agree with it philosophically or not. Your personal money is exempt from the contribution limits that Montana has set on individual limits to campaigns.
Even though their money comes from their corporation.
Well, no, it can't come from their corporation. It has to come from their personal.
So they have to show
Specifically.
in their own income, they
Right.
pay taxes on.
Right.
Anybody else? Okay, so the next thing we have on the docket is the discussion between the two of you, and I wonder if it's easier if I move over to there?
Oh, sure.
And you move over here so that we don't have to have the mic quite as far. Okay, you said, we have a new knee on the commissioner here, so that's.
Yeah, it wasn't a baseball bat.
It wasn't a baseball, that's good, that's good. All right, so now we're going to hear a discussion about the future of the Disclose Act. Where do we think we're going with this act, which has put us in a pretty good place? So, the two of you?
Talk to me.
I expect there to be a wholesale challenge of the act by the people that opposed it during the session. And this were groups like Americans for Prosperity, Montana Club for Growth, was it? Yeah. They clearly don't like it, and I think they're waiting for the right case to file a challenge on. And this isn't anything unusual. Election laws federally have been under attack. As you recall, some of the major federal reforms have been challenged, like McCain-Feingold. Kind of the rule of thumb federally is Congress figures out a way to try to stop some of the election practices that occurred, passes a new law, and then it's immediately under challenge. So I don't think this is anything extraordinary that it would be challenged, but I think we will see challenges. I don't know of any at present other than the ones I mentioned, but I certainly expect those and others. What do you think, John?
I think that electronic reporting is here to stay. I don't think they can roll that back. I mean, I think it will work, and by the time of the general, we'll get it to where the information is better. So I think that part of it will stay. Probably the additional reporting period is here. I think the push will be enforcement, will be whether or not, because you can't, if you don't enforce it, then you can undermine it.
I could tell you a little of the history of the office. The way the law reads, the commissioner will come up with a sufficiency statement, and then it goes to the county attorney in which the candidate resides. I may be wrong, but I don't think a county attorney has ever taken any of these cases to court, have they, John? Never, over the course of this, over 41 years. So if anyone is going to take legal action to enforce the law, it's got to be the commissioner. This is a little off topic, but I used to get a lot of calls as a reporter about robocalls, the automated calling, and Montana statute says they're illegal. The commissioner has no authority to enforce it. It's up to county attorneys. And at times, county attorneys, or even attorneys general, say, call your county attorney. To my knowledge, there's never been a county attorney who's taken it up. I think they feel like they're tracking down more serious crimes than robocalls. So the law's on the books, not enforced. There was a law last session, a proposed law to assign the commissioner the power to enforce the ban on robocalls, but it failed. And whether that'll come up again, I don't know. It wouldn't surprise me, but I think it's a tough sell.
Yeah, Chuck's right. So I mentioned we were 60 complaints behind. We caught all those complaints up. We're current on the docket now. Every single complaint was filed in district court in enough time to preserve the statute of limitations. That took away one of the legislature's concerns, which is that the commissioner's office was slow and toothless. Chuck remembers when that was pretty much in every news article. But remember the antipathy. You know, you've got an enforcer going against a public official. And that's always going to be cause for concern. It was deliberately set up that way. It was knowing that it was set up that way. I believe everything's been done appropriately, but it's still going to be, I think it's going to create some major backlash when we get into the next session. And the next commissioner will inherit that, but it isn't going to be any worse than when I inherited it. So.
Any questions? Is that it for the two of you?
Well, I am relatively optimistic about the future of the office. I think that with the people of Montana have always backed it, and I don't think it's misstepped. So I think we'll have it.
I think the additional transparency and the electronic filing will make the office all the more valuable to average Montanans to check on who's contributed to the two candidates or more in the primary, whereas in the past it would have taken a lot of work to get those. Now you can just go onto your computer at home or at the library and get a pretty good profile of who the donors are. And I maintain that you show me the list of donors to a candidate and I can probably guess fairly well how that individual will vote on the key issues in the coming session. So I think it'll be an empowering experience for those people that use it, and I would hope that groups like yours will, maybe put on a Saturday presentation at the library or here showing how to look up those records and giving the voters a chance to check on their candidates and get a good look at who's donating to them.
Okay, anybody else? Okay, so has everybody turned in your questions to Nancy, except me? All right, Nancy, so why don't you just begin, can you?
I will just hold it, that's fine.
Okay.
It's interesting technology. So just a quick follow-up question about the future before we move on to these questions. If I'm correct in making this assumption, Commissioner Moll, your term as commissioner ends the end of 2016.
December 31st, 2016. Commissioners are appointed in a 6-year slot. It doesn't matter where you get in. And even though I'm the 4th commissioner, I am in seventh commissioner's slot. So at the end of that slot, I'm done.
Right. So what can you both comment on, what's the likelihood that any future commissioners are going to be as strong in wanting to enforce all of this as you have been? What is there to give us any hope that that's going to happen, or what can we do to try to help make sure that happens?
Well, the way it would work is Governor Bullock, who is in office through the end of the year, regardless of whether he wins or loses this fall, would make the appointment. But the Senate would confirm it next year. If we have a Republican Senate, which is very likely, they start out with a huge edge. 16 Republicans are holdover senators and 9 Democrats are holdovers, and they're 25 to be elected. But I'd be very surprised if Republicans don't take the Senate. You know, they will determine whether the commissioner that Governor Bullock appoints is confirmed or not. If Governor Bullock loses the election to Greg Gianforte, the Republican candidate, I would expect that the Senate would probably reject Governor Bullock's choice as commissioner, and he'd appoint his own. So you just don't know. It's an office that has attracted people of all different stripes. From my observation, I think having an attorney in the office is definitely an asset, although there have been some very good commissioners who weren't attorneys. It's, you know, it's the old line, I think Harry Truman said, if you're in politics and want a friend, get a dog. I mean, the commissioners, he can't donate money to people running for office, or she. You can't really hang out with them, because that wouldn't look too good if you're out to dinner with the governor or the governor's candidate. So it's a fairly isolated existence, and I think takes a special person that can do it and is willing to make the right decisions regardless of where the chips fall. So we, like I said earlier, we've had some very good commissioners. We've had some pretty good ones. We've had some so-so ones. We had a couple of duds. So my advice to you is pay attention to who the governor picks, and if you think that person is worthy of your support, let the governor know, or let the Senate know. Who knows who will be picked, but I do think having an attorney there is a definite advantage, because Commissioner Modell has on his staff another attorney, so that gives him the firepower of 2 attorneys rather than 1, and all these cases are legal, and I think having the 2 attorneys has been a godsend over there.
From my perspective, the ideal commissioner is a retired attorney, because you don't, and with family support, I might add. If you don't have your family support, you shouldn't do it, because it's a pretty demanding job. But a retired attorney, because your career's over and you can't be blackballed for something that you've done. And so that would be my preference, would be. But I don't know of any retired attorneys who are going to apply.
They're not lining up for this job?
No, they're not lining up, but I am hopeful.
I don't remember which year it was, but Common Cause of Montana, on one occasion, and John Modell was, I don't know, were you the state director, state president, or?
You mean that lawsuit against Arkenbury?
No, there was a case where Common Cause of Montana, on its own, set up a selection process, and John was part of the process in some way. He invited candidates to apply, interviewed them, and made recommendations to the governor and the Senate leadership. You may disagree. I think it was sort of was a bust. The governor at the time ignored them and didn't pick the person you recommended. But so I don't know that that's the right approach. But I do think if any of you are interested, or you know someone would be good at it, you ought to forward their name to the governor. Because when John Modell was chosen, I think there were 6 or 7 candidates, weren't there?
13,
13, okay.
and then 5 were interviewed.
Wow.
Yeah.
Hmm.
And there were some people that had very interesting backgrounds, but governors will listen to people from the public that say, I think Mary Jones would be a great commissioner. She's an accountant, or she's a lawyer who does tax work or whatever. And maybe you could interest some of your friends and neighbors into applying for the job. It's not a great paying job, as the pay doesn't begin to follow what the responsibilities are, but it's a decent paying job. But again, it has some limitations. Under state law, the commissioner, after he leaves, cannot run for state office for 6 years, I think, isn't it? Something like that,
They've
4
been-
years.
they've been-
Oh, did they? Okay. I always thought that was probably illegal, but no commissioners, to my knowledge, have ever run for office after they've served.
And just a follow-up question again about the future. Is there any sign that the legislature will attempt to revise all of this in the next session?
Well, every session, since I've known, there's been bills in to revamp the commissioner's office in one way or another. Yeah, so I would expect that there would be in 2015, but I think some of it's going to depend on these Senate elections too. There is a philosophy within the Republican Party that pushes more towards individualism, libertarianism, I guess, and that group of senators is more interested in no campaign finance reform. I think that's fair. So, Chuck?
The politics at the 2015 and actually the 2013 session were such, as you probably know, there was a bitter division in the Republican Party, a lot of it stemming from this dark money that was used to go after some of the candidates, and the surviving ones tended to be very critical of this and very much in favor of efforts to strengthen our campaign finance laws, as well as other things. And absent that split in the Republican side, I'm not sure the Disclose Act would have passed both houses, and frankly, I'm not sure Commissioner Modell would have been confirmed. But there was that split, and I think it will be there again this session. To what extent it will be there, I don't know. But the Disclose Act passed both houses due to that. And in the House, it was nip and tuck. Representative Garner withstood, like I said, 10 or 12 amendments, and had one person voted wrong on them, or wrong in the sense of voting against it or right, depending. Amendments would have passed to essentially gut the bill.
Nancy?
Okay, question for, I believe, Commissioner Modell. How are donations from, for example, a person who is running for office who has a lot of personal wealth, how are those interpreted by the commission?
They're legal, and so the question is, are they fully reported and disclosed? If it's a contribution by the candidate to his or her own campaign, they list it as a contribution, goes on the income side, and then on the expense side, you can see how it was spent. If the candidate intends to loan the money, then it is a loan, goes in on the income side. The difference between a loan and a contribution is that it's possible a candidate can repay the loan to himself or herself if they get contributions from third parties and enough funds to repay it.
This is more of a nuts and bolts question. How can voters and the public tell if electioneering communications in the mail or on TV or online or whatever violate the Disclose Act and campaign laws? And if they do, what do we do to report it?
You get you you see something electronically, you get something in the mail. There should be an attribution stating who paid for that electronic advertisement or that mail advertisement. You go right to the commissioner's website, you put in the name of that entity. You should immediately call up their campaign finance report that's filed under SERS. Right on there, it should say how much that advertising cost, where it was, everything should be displayed. And it doesn't matter anymore if it's issue advocacy or express advocacy. That question was sophisticated. It used the word electioneering communication. Electioneering communication means that it is something that doesn't directly say vote for or against a candidate, but it implies a vote for or against a candidate because it lists the likeness of the candidate and is mailed within 60 days of the start of voting, basically 90 days before the date of election.
So with that, then, leads right into this next question. This is a piece of material that was in a newspaper. It's a thank you to Senator Steve Daines, Senator John Tester, and Representative Ryan Zinke for their leadership and diligence in fighting for permanent authorization of the Land and Water Conservation Fund, et cetera, et cetera, et cetera. Would this be considered electioneering communication, as I'm assuming this was just published within the last week or so?
That is, those were all federal candidates, and so we're not within the scope of Montana's Commissioner's Office. Our candidates are state, our laws are state candidates, and the vigor with which we can enforce, report, and disclose applies to state candidates from the governor to the city commission and anything in between, but not to federal candidates. That's the Federal Election Commission.
Okay, so that answered that question. All right. If this had listed, well, it wouldn't be irrelevant. But we
State,
only, yeah.
if it had been state candidates?
Yes.
Yes, you would have expected that. You would have known how much that ad cost. It would have been allocated 1/3 each to each of those three candidates. The dates it would have been, everything you should know about that ad under the Disclose Act should now be reported and disclosed and made electronically available to the public.
I would take issue with one thing that John said. When you look at campaign finance reports, you may not see, ad that ran on television October 4th through 6th. A lot of times you just see advertising or television advertising or where it doesn't specify the specific dates the ad ran, and it may include mailers or radio ads.
That's true, but that's a campaign practice violation. And that's what we cracked down on in 14 against everybody from the Montana League of Rural Voters to the Montana Family Foundation. Didn't matter where you were on the spectrum. The public is entitled to know the date of the expenditure. Now, we don't have that on the contribution side. We don't require, that's an error in our law. It's the reason why we got a 92.5 on our report from the National Institute of Money and State Politics, whereas Maine got a 98. But 2.5 points of that was our failure to require the date of contributions, which we hope to fix.
Dates of contributions are very important
Oh, I
because
know.
you can look at the dates and say, oh, candidate X or Governor Y or Auditor Z must have been in Billings on the 17th because look at all these donations from Billings. So I think it's a pretty critical number, and it is on the federal election.
Yep, and I don't know how it baffles me that as careful as we were. Now, that wasn't part of the Disclose Act. We didn't go back and look at that. And so it is, we got a 92.5, so we're one of the best states in the union in terms of what we provide to our public, but we don't require the date of that contribution, and I really don't know why. But we do on expenses. If they don't have it in there, then file your complaint.
It wasn't long ago that the office got failing grades from national groups that rated the state. So that's a remarkable improvement.
And a follow-up to that, are other states contacting your office now to find out what we have done and are starting to model some of what they're doing after what we have done?
They did originally on reporting and disclosure, but I think right now they're just, what Judge Ray Dayton does in regard to Mr. Wittig's situation is equally, so there's a tremendous amount of work on the Commissioner's office in finding the original sufficiency decision, a tremendous amount of work on Mr. Gerussi's part to prepare and present this case to the jury, along with Sarah Arnold and all the witnesses who came in and testified, and all of that's important. Then you've got this 12-person jury. And were you there when they were picked?
No.
Okay, it's baffling to me how you could find 12 people in Helena, Montana who knew less about politics. I mean, these people, they didn't know who Mr. Wittig was. They didn't have a clue. They didn't know what the Commissioner's office was. They didn't have a clue. And yet, by God, when it came time to make that decision, they were so strong. That jury verdict, when it was 10-2 and they were polled and each juror had to deliver their individual response, Mr. Wittig's attorneys can poll the jury, they did poll the jury, is this your verdict? And yes was a verdict that reflected those decisions against Mr. Wittig's position. Those 10 yeses weren't yes, they were yes. I mean, they were, it just restores your faith in,
That's great.
in humanity. So that decision of that jury, so you got the Commissioner's office's work, you got Mr. Gerussi's work, you got the jury verdict's work. You know what? Equally important to all of that is what Judge Ray Dayton is going to decide on the penalty phase, because he can take that $19,599 for a corporate contribution, treble it. He can treble it for reporting and disclosing. He can remove Mr. Wittig from the office he holds now. He can remove him from the candidacy he's seeking. He can prevent him from ever filing again unless he files the campaign finance reports. If the judge makes a strong decision in some combination of one or more of those things, we're going to get a lot of attention as to how we got there. But this penalty phase decision, June 17th, 2016, is important.
Is it fair to ask you what you're recommending?
The Commissioner's office will recommend all of those things that I just said. Today's what? Yeah, we'll be recommending all those things. But the jury's decision was the jury's decision. It's not the Commissioner's decision anymore. It's a group of Montanans as a jury that made that decision, and it's going to be a judge that makes that decision. That's what due process is. The Commissioner's office is just a role in that. So it's his decision. I'm going to be waiting with bated breath. Yeah. Can't be any less than 19,599 twice, because the jury already found basically 40,000. So the judge can make it more, or he can leave it.
So this is a clarifying question. Could you clarify what disclosure is required of dark money organizations that attempt to influence election outcomes, supposedly without coordinating with the campaign?
Want to try that, Chuck? You want me to do it? Full reporting and disclosure to the absolute penny of what they're, as an independent expenditure, but it's fully reported and disclosed. We should not have any dark money expenditures. Now, as Chuck said, it's still going to be dark, partially dark, because if you're an incidental committee, that is a committee that is involved in other activities. Orvis Rod Company did some advertising for a clean water initiative in the year 2000. Orvis Rod Company makes all its money selling fishing gear, fishing vests, lures, all that stuff. And so the money it spent is Orvis's money, right? So Orvis just reports that money, the source of the money, as Orvis Company, correctly so. But if you're one of these nonprofit groups that Chuck is talking about, you don't know where that money's coming from because they're not selling widgets, they're not selling pencils, they're not selling fishing gear, they don't have a business. But they're not required to report the source of their contribution unless they've solicited expressly for the independent expenditure. So we're still dark on the contribution side, but we're not dark on the expenditure side. Senator Ankeny talked about getting bushwhacked. He didn't know who the group was, when they did it, how much they spent. That can't happen anymore. That group is required to report and disclose the expenditure, the date of the expenditure, the amount of the expenditure. So we've got, and if it's a political committee, then they have to report the source of the money that they used to make that expenditure. So we're closing in on it. We're not 100% there, but we're a long ways down the road. Chuck, why don't you react to that? Because you wrote on dark money more than any other reporter has ever written, you and Mike.
I wish it were tighter on that. I don't know if do you think there's constitutional problems in doing that, or is it?
The contributions?
Yeah.
Yeah. And we were just, I think we're pretty constitutionally solid where we are with the Disclose Act now.
Yeah, I hope so. Like I said earlier, the experience with, when you put up the barricade for campaign finance to tighten and more strongly regulate it, somebody always finds a way to crawl through, and that's been the case federally anyway, and to some extent Montana. So I view it as an ongoing process, and you and your successors will be able to say, and all of you, that this is a loophole that needs to be fixed, and bring it to the commissioner and bring it to the legislature, because that's the story of campaign finance reform over the years, is someone always finds a way around it. PACs were allowed in the wake of the Nixon election in '72, when you had the committee to re-elect the president was getting cash from groups, and our former Governor Babcock here was the bag man for Arm & Hammer, taking cash to use as hush money for Howard Hunt. And so, Montana's, like a lot of states, has a soiled reputation when it comes to campaign finances, going back to the days of when William Clark wanted to be elected to the U.S. Senate, and $100 bills were thrown over the transom at the Placer Hotel in Helena. And the 17th Amendment was passed in large part because of the corruption in Montana. So now we have direct elections to the U.S. Senate. Previously, it was the state legislatures that chose senators. So it's a give and take, and I think we'll find loopholes, and we'll try to figure out how to close them, and then parties that want to break the law will find ways to get around it. It's an ongoing process, and I don't think that'll end.
Well, and I think Chuck's right, but here's my bottom line on this. The more confidence Montanans, all of you, all of us, have in our elections, the more confidence in the fairness in the elections, the better our governance is going to be, because our legislators will come out of that with a solider background. We'll get fewer of the so individualistically oriented legislators that they have no idea what the public trust is. And if Montanans can pass that I-166,
Yeah.
we can deal with whatever's thrown at us, whatever circumstances are thrown at us, and keep going. We just gotta never quit trying.
Nancy, one more question.
One more question. Okay. Is there any intermediate work needing to be done between the commissioner's data and the public, or dissemination of the data? Who can do it, and can the media be active in this?
Absolutely, the media can take the you know, the data, probably downloading it and putting it in the spreadsheet, and could do a story on each race in Missoula or Bozeman or Billings or Helena, and say, you know, a little thing, here's where Mary Smith got her money, here's where Bill Jones got his money. It's hard to do inside and outside district, but you could certainly do what percentage came from Missoula versus outside of Missoula or outside the state. It takes bodies, and unfortunately the media today, all forms really, don't have a lot of extra bodies around, but I think it's important that citizens press for them to do it. If they don't do it, no one will probably. This institute I mentioned, the National Institute for Money on State Politics, has a fabulous website, and it's www.followthemoney. And the only problem is this data won't get up promptly because they're doing it in 50 states. But you can go on that website and look at, you know, who donated to your legislator's campaign the last time, or you can look up your next door neighbor, look and see how she donated or he donated. It's filled with great data, and they have a staff of about 20 or 25. They got a MacArthur Genius Grant. It's funded by grants. They play it right down the middle. They classify donors by what's called the SIC code, Standard Industry Code. So if you're a banker, that goes under finance. Was it finance, insurance, and real estate? They have categorizations they use throughout. There's a similar group that's actually been going a little longer called the Center for Responsive Politics in Washington that does the federal races, President, Senate, House, and PACs. And its website is www.opensecrets.org. And these two websites are really fabulous. There is a delay. For U.S. Senate filings, whereas the House submits them electronically, the candidates for the U.S. House, so they go up right away. The U.S. Senate, by practice or rule, requires them to be retyped in by stenographers, so there's a 6-week delay sometimes in getting U.S. Senate contribution reports online, which is really criminal in this period we live in, I think.
Okay, yeah.
Could I just add one thing?
Model, sure.
As far as the commissioner's CSRS campaign electronic reporting system information, play with it. We now have it and it worked. We know candidates and committees can use it. It is usable. We now know that that information can get up electronically and data can get up electronically. Now we have to shape it so that it's in the form that can best be used by the President of the Republic. So get in on it, give us ideas, because that's the next thing that we'll be doing.
Excellent.
Hopefully before the general.
Okay, well, let's give some applause.